Sorry for the late broadcast. A few minutes late today, but welcome to the live stream. For those of you who do not know who I am Boss Attorney Bree. I am a licensed attorney in California, and I own my own law firm where I help business owners protect their business and brands through trademarks, copyrights, and contracts. And I also run this lovely YouTube channel here where we talk about celebrity lawsuits and influencer lawsuits, and then a little bit of business education. So, if you are new here, make sure that you subscribe if you are interested in these topics. If you are a returner, welcome back. We have some good cases to get into today. As you can see by the thumbnail, we are going to be talking about the Kardashian-Jenner family. And specifically, we are going to be talking about Kendall Jenner and her trademark infringement lawsuit that was filed last week. But before I started this live stream, I did come across another lawsuit involving another influencer brand, and that involves the infamous Ace family. If you do not know who the Ace family is, they are a influencer family, which includes the mother, the father, and the three children. And it involves Catherine McBroom and Austin McBroom. And they have just had a bunch of lawsuits going on since 2021. So we are going to be talking about their newest lawsuit that was just filed against them for breach of contract. But since I didn't put that on the thumbnail, we'll be getting into that a little later on in the video. And just give me a second. As always, I am having issues with my whole setup here. All right, so we are ready to get started. And first, like I said, we're going to jump right into it. And we're going to be talking about the Kendall Jenner lawsuit. Okay, so just give me 1 second here to pull it up onto the screen. As you know, I always have issues with this. Or if you've been watching for a while, you know I always have issues with this. So let's go here, share it. And we are talking about Kendall Jenner first. All right. Talking about Kendall Jenner and her lawsuit. If you keep up with the Kardashians, you know that they are always involved in scams and lawsuits. And today we are going to be talking about Kendall Jenner and the lawsuit that she actually has going on. And I'm sorry I keep stopping. I just keep having all these issues going on right now. Okay. So let's see if this is working. Okay. This is working. Let me know if you guys can hear me in the chat. Let me know where you guys are from in the chat. If you're watching this on the replay, go ahead and comment below that you are in the replay gang. And like I said, I'm sorry that it has been a struggle for the last few minutes, but we are getting right into it. Today, we're talking about Kendall Jenner. She is one of the younger children of Kris Jenner and the Kardashian family. And she recently started a tequila brand. But now she's being sued as of last week for what's called trademark infringement. If you watched last week, we went over a Rolex case that was trademark infringement. So today we are going to be talking about a similar case, but instead of being at the end of the lawsuit, we are now at the beginning of the lawsuit because the complaint has just been filed and Kendall Jenner's company has not necessarily responded yet. So we're going to be talking about how she is being accused of trademark infringement. And again, guys, we are going through the complaint. So just to make sure everything is clear, these are all allegations and have not been proven to be fact. I am literally just reading exactly what the attorneys for this Clip Bandits company, what their attorneys put into the complaint. Again, it has not been proven to be fact. And Kendall Jenner and her company will have a chance to respond to the allegations on this lawsuit. So as we can see, it has been brought in the federal court because trademark law is federal law. And it has been brought into the California West or Central District of California Federal Court. The plaintiffs in this case is Clip Bandit LLC, and they are the owners of the 512 tequila brand that is suing Kendall Jenner's K and Soda LLC, which is Kendall Jenner's business, doing business as 818 Spirits, which is what the tequila is called. They are being sued for federal trademark infringement, federal unfair competition, and false designation, state common law trademark infringement, state statutory unfair competition, and state common law unfair competition, including injunctive relief. I don't know why they listed that twice. Maybe they meant to put state or common law false designation. I don't know. But they're demanding for a jury trial. Again, if you guys are watching in the live stream, let me know where you're from. If you are watching on the replay, again, let me know where you are from. And let me know if you guys have heard about this case, because it was recently filed last week. So it is brand new. And let me tell you, the attorneys in this lawsuit started off swinging with their shade that they are about to be throwing at the Kardashian-Jenner family. So let's get right into the opening statement of the complaint. It starts off with the Kardashian-Jenner family strikes again. Because as we know, they are always being sued for copying other people, trademark infringement, stealing from smaller companies, stealing from smaller creators. And so these attorneys came right in swinging. The Kardashian-Jenner family strikes again. This time, Kendall Jenner has associated herself with a new tequila brand, 818 Tequila, and intentionally copies plaintiff's tequila brand, Tequila 512. The similarities are so striking that this cannot be a result of coincidence. And so they start off this case just showing the bottles. If you guys are watching on the live, let me know if you think that these bottles are similar. Me just looking at them right now, they do look a little similar. Of course, the numbers are different, 818 and then 512. But at the same time, the letters and the numbers, I feel like the 5 and the 2 can be shaped into an 8. They use the black lettering. They have a yellow color theme. And it doesn't, and for those of you that don't know about trademark infringement, it does not need to be exactly the same as someone else's trademark in order to be considered trademark infringement. So this to me does look like 512 does have a claim here. Like I said, Kendall Jenner has not responded yet. This was filed like last week, so they have a couple of weeks to go ahead and put in their answer. But from a source that I looked up yesterday, it did say that Kendall Jenner's company has commented on it and feels like there is no claim for relief here. But looking at this picture, let me know what you guys think. Do you think that this could be considered similar? Let me go ahead and make it bigger for you guys to see, so you guys can see up close what I'm seeing. And then let me go ahead and make it bigger on my screen. Oh, that's too big. Okay, so like I said, I do think that it does look pretty similar, but it will be up to the court to decide whether it is truly a similar or should be considered trademark infringement. So let me go back and make myself a little bit bigger so we can go ahead and keep going through this lawsuit. All right. So back into the shade of what we call a complaint. Plaintiff Clip Bandit LLC brings this action against owner of 818 Tequila, defendant K and Soda LLC, DBA 818 Spirits, long names here, for the trademark infringement, false designation of origin, and unfair competition. Plaintiff sells a popular tequila in the United States under the brand 512 using a highly distinctive logo and color scheme that has been in place since 2015. The 512 brand is one of the fastest growing tequila brands in the world and has been highly lauded for producing high quality premium tequila, including winning the coveted Double Gold and Best in Show award at the San Francisco World Spirits Competition. So basically what the plaintiffs are trying to establish right here is that they have a tequila brand that people know about, that has a trademark. So people understand this delicious tequila that has won Best in Show as a originated from the 5112 brand. And the fact that Kendall Jenner's bottle looks just like their bottle, in their opinion, that it is causing trademark infringement on their 5112 tequila trademark. So moving back along, the 5112 brand is hugely successful, valuable, and popular among tequila drinkers. Plaintiffs have a federal trademark registration in the 5112 or the 512 brand, and has a pending application for registration of the trade dress that includes the distinctive and immediately recognizable 512 mark in black lettering inside a vertical yellow rectangle. Plaintiff's Tequila and its 512 branding as associated trade dress are a tremendous success story in every sense. Again, we're going back up to the picture, and this is what they're saying. It looks alike. They said it has the black lettering, it has a prominent area code, it has this yellow rectangle, and then as you can see on the Kendall Jenner's brand, it is a black lettering, area code, and this yellow square. And so they're saying that not only is the name trademark infringing, the actual trade dress is trademark infringing. And so we'll get a little bit into why they are claiming about the trade dress and the fact that you can actually trademark your trade dress, which is kind of like the how your product looks. And you can also actually trademark like product design. This one wouldn't necessarily be product design because it's a bottle, and most bottles are shaped the same. You can't really trademark this specific shape of the bottle, but the trade dress and the way that they make it appear can be trademarked, and that is what they are arguing here. They're not saying that the name is exactly the same. They're saying that the actual trade dress is too similar. And remember, for trademark infringement, it does not have to be the same. It just has to be confusingly similar, the same or confusingly similar. All right. So in 2021, defendant launched a competing tequila, which is Kendall Jenner's company, but instead of creating its own branding, and this is where they're going to start saying, hey, they copied us. And without plaintiff's knowledge or consent, defendant simply and blatantly copied the branding of plaintiff's 512 tequila. In particular, out of the entire world of naming options open to it, defendant chose a 3-digit brand name with a central one that, like plaintiff's 512, is a prominent area code. So they're not saying it's the same, but they're saying they copied their branding idea by naming the tequila after an area code. And out of the entire world of colors and shapes to use for the product design, defendant chose to copy plaintiff's distinctive black lettering inside a vertical yellow rectangle that has acquired so much goodwill over the years. Like we've seen the bottle, it does look pretty similar, but we're going to keep going into this lawsuit and see what else they are actually alleging that Kendall Jenner's company actually copied, okay? That is, rather than trying to compete on their own merits, defendants simply used plaintiff's marks with immaterial tweaks, hoping to grab plaintiff's customers as a ready-made customer base by deceiving them into falsely believing that defendant's 818 tequila is another product sold by plaintiff or has some affiliation with plaintiff's 512 tequila. Comparing the two products, customers would easily believe incorrectly that the products are related. Indeed, looking at defendant's product, which came along many years after plaintiff's highly successful product, it is difficult to conclude anything other than that defendant's copying of plaintiff's distinctive trademark was completely intentional. And again, we can go back up and look at this bottle. I think they do look pretty similar. I think they'll have some arguments to make for sure because they're not necessarily using the same numbers on the bottle. And they actually flip the way that it's written. So they have 818 tequila and they have Tequila 512. They both have Blanco on there. And I do think that they look similar, but I do also think that it will be a fight to prove it as well. And we'll see what Kendall Jenner's company actually responds to the lawsuit. Back into the complaint, the defendant's infringement, unlawful and destructive in itself, is all the more troublesome here because of the wrath defendant has drawn up upon itself in the industry and within the tequila drinking community. And so they're basically going to get into some of Kendall Jenner's bad publicity that she has already had with the tequila. If you know the Kardashians and the Jenners, you know that they tend to get bad publicity on certain things that they do. And with this tequila brand, they actually did have some bad publicity on it, or Kendall Jenner did get some backlash on the publicity when she first launched the product in 2020 or 2021, I think. All right. So, in particular, notorious celebrity Kendall Jenner of the Kardashian family infamy is a spokesperson for defendant's 818 brand, and in connection with its launch, Jenner and the 818 brand were widely accused of cultural misappropriation of the Mexican tequila heritage for trying to seem to have Mexican roots. Okay, we don't need that popping up. Okay, we having all the emails pop up today. Trying to seem to have Mexican roots and respect while getting things substantially wrong. For example, according to a 2021 article from InStyle magazine entitled Kendall Jenner's Tequila Brand Actually is Problematic, celebrity brands are pillaging Mexico's agave to make subpar products. She's just the most visible one in a Diet Prada post about the launch called attention to concerns Mexican and Latinas. And I think they meant to put an A there. Latinx, I guess plural. People have about Jenner's products, including charges of cultural appropriation and fears that workers who harvest agave and make tequila might be exploited. So they're basically saying that the fact that all of these celebrities are making tequila brands are possibly going to lead to the overworking and the exploitation of the part of Mexico that harvests the plant that is required to make tequila, which is the agave plant. And so they're saying that all these celebrities are starting these brands and potentially going to harm the people in Mexico that are in charge of actually producing the plant for this tequila. There's also some concern that celebrity tequila trend is causing real harm to the agave producing region of Mexico. The article goes on to discuss other conspicuous graphs from defendant, including mistakes of Spanish grammar that scream inauthenticity. All right, so they're saying even on her bottle, she's not even really using proper grammar. Like she's not even hiring the right person to make sure that the things that she is writing on her bottle is actually proper Spanish. So that is very interesting. Defendant also charges substantially more for its products, which are more cheaply distilled only 2 times rather than the 3 times plaintiff's products are. Customer ill will generated by the higher price and curtailed distilling process will be targeted at plaintiff due to confusion between the products. Again, they're saying that what Kendall Jenner's company is doing is giving them backlash because the bottles look so similar. If you place them right next to each other, people might think that they are the same brand. They will have to look very closely to determine that it is a different brand. And they're saying the fact that Kendall has already been accused of cultural appropriation, it might fall onto their branding or onto their brand because they do look so similar. All right, and then we have, moreover, defendant's infringement and an attempt to trade on plaintiff's goodwill did not stop there. In May 2021, defendant promoted its tequila as a virtual product that could be purchased on the mobile app of Kendall Jenner's sisters, sister, the Kim Kardashian Hollywood app. And so there's a picture that Kim Kardashian, or that the bottle was on the Kim Kardashian app for sale, and it looked just like the bottle that plaintiffs have, that the 512 tequila branding had. And they basically told them to take it down, which they're going to get into in a moment. Plaintiff did not authorize this use in any way. Either defendant intentionally used plaintiff's bottle, hoping to further blur the lines between the two products, or defendant itself confused about the difference between the two brands. Either way, the incident further shows how invidious defendant's infringement is, and that it must be stopped. When plaintiff contacted defendant about the infringement or the use of their bottle on the Kim Kardashian app, defendant changed the brandings on the bottle in the app to a green circular branding, very different from the yellow rectangle that the 818 brand actually uses on its bottles. There is no reason defendant could not and should not similarly change the branding of the actual bottles. So they're basically saying when they called Kendall Jenner's company or Kim Kardashian's app out for using the same branding or actually using plaintiff's bottle on the Kim Kardashian app, they went ahead and changed the tequila bottle into including something with like a green circle on it to further distinguish that they are not trying to copy the plaintiff. And so what the plaintiff is saying, they don't understand why Kendall Jenner's brand cannot just also do that on their bottle. Why don't you change it to the green circle on your actual bottle as well? All right, so defendants infringing branding has already caused actual confusion in the marketplace, with the consumers thinking defendant's brand is related to plaintiffs. Defendant is not entitled to confuse consumers in this way or to steal sales from plaintiffs through its deception, or to cause the public to take the substantial ill will reportedly generated by defendant's cultural insensitivities and grasp and transfer it to plaintiff, thereby tarring plaintiff with a non-existent but perceived relationship to the 818 brand. If defendant wants to shoot itself in the foot with its own positioning and marketing and higher price and reduced distillation, that is up to them, but they cannot be allowed to drag plaintiffs down with it. They're basically saying that the way that Kendall Jenner is running her brand is not a good tequila, and it is harming it's not a good tequila, and their branding is not appropriate. It comes off as misappropriation, and they don't want that nonsense that's going on over there to be reflected onto their brand, which makes sense. Like, why would you want someone else to ruin your brand? If you're going to ruin your brand, you would rather do it yourself rather than having someone who's not even associated with your company do it for you. So let's get back into it, and let me know if you guys have any questions. If you're watching this on the replay, go ahead and drop your questions in the comment box below. This is a pretty interesting case. So we're just kind of at the beginning of the case, and we're going to kind of pop into all of the allegations a little further down. So again, let me know if you guys have any questions so far on this case. Defendants copying and infringement of plaintiff's distinctive and valuable marks on competing goods and services is likely to confuse consumers and will continue to likely confuse consumers and violate the Lanham Act, which is basically the laws for trademark, the California Business and Profession Code, and the common law. Defendant's infringement has injured and will continue to injure plaintiff and its 512 brand. Accordingly, plaintiff seeks injunctive and monetary relief to stop and, to the extent possible, remedy defendant's unlawful and unethical conduct. So they're basically saying what Kendall Jenner's company is doing is infringing on their trademark. we are going to continue to go through the lawsuit just to kind of get some more facts of what they're alleging, because that part of the opening was just a brief statement of the nature of the action. We're next going to go into the actual facts of the case that the plaintiffs will be presenting to the court. And then we're going to get into the actual causes of action on the case. And before we do that, let me see if I can actually find that picture of the Kim Kardashian tequila app. Because I saw someone posted in their own video that they did on YouTube. Hollywood. Okay, let me see if we can see. Yeah, no, they're not really popping that up too easily. So we might have to skip that one this time. Yeah, I don't know where that person got that picture from, but yeah, it definitely did show the tequila bottle with the colors that the plaintiffs are alleging. So, of course, in the complaint, they talk about the parties and how the plaintiffs is a Texas limited liability company. And then there is a Delaware limited liability company, which is the K and Soda, which is Kendall Jenner's brand. And then they established jurisdiction as far as it being the federal law, so that this court actually has jurisdiction over the case. So we are going to pop back over onto sharing my screen. Is that big enough? This is bigger, so that might be a little bit more helpful. Okay, so they also want to go into additional facts common to all counts. So these are facts that could potentially affect all the counts alleged in this action. And I hope this is big enough for you guys to see it. I think so. All right. So plaintiff owns a United States trademark for the word 512 directed to, among other things, tequila, distilled spirits, and it is registration this number. Plaintiff also has a pending application for the United States registration and a design mark including the number 512 and the word tequila inside a vertical yellow rectangle directed to, among other things, alcoholic beverages, namely tequila, liquor, spirits, distilled agave liquor. So they went ahead and filed a trademark for the actual trade dress, which I talked about earlier. You can get a trademark for so many different things. The main things is going to be your brand name, your logo, or a tagline or a slogan. But you can also trademark things such as your product design. You can trademark sounds, you can trademark smells, you can trademark colors, and you can also go ahead and trademark your trade dress. So it's kind of whatever you use to advertise your business. If you notice, and this can kind of go both for facilities design and for trade dress, but when you go into an In and Out, all of the restaurants look the same on the inside. You're getting that same white, yellow, red, and then the tables look the same, and the counter looks the same, and the kitchen looks the same. That could be considered facility design or trade dress, but this is what this lawsuit is actually alleging. They're not saying that the 818 is exactly the same as the 512. They're saying that it's similar, because they decided to use a area code to name their tequila brand, which in their opinion was unique to them. But on top of that, they are also saying that it is similar that Kendall Jenner decided to use the same type of trade dress. They used the yellow square with the black lettering, the boxy lettering. And so for those of you that did not catch the beginning of the stream, I'm going to pop back up to kind of show you what it actually looked like in the complaint. Let me remember what page I'm on first. All right. So this is the picture that they submitted to say that it is super similar. What do you guys think? I can see what they're saying as far as the trade dress goes. It is that yellow square with the black lettering, and it's kind of bulky lettering. The bottles, it's not too much you can do about bottle shape, honestly. A lot of bottles are shaped like this. But the fact that this one is just a little bit more stubby, and then the colors are the same and all of that, I think it is a little bit more than a coincidence. And the thing is that the Kardashians and the Jenners are known for copying people, especially smaller brands. So let me know what you guys think. Does that look similar to you? I think they have some standing there. Are they going to win? That's a different question, but I do think that they have standing for the most part. I don't think it's frivolous. I think they can prove it a little bit. Okay. So, plaintiff markets and distributes tequila within the United States under the 512 marks. As a result of plaintiff's substantial expenditures and efforts, the 512 mark have come to signify the nature and high quality of the goods and services offered by plaintiffs, and have acquired distinction, reputation, and goodwill belonging exclusively to plaintiff. The 512 marks have been in continuous and exclusive use as trademarks in commerce by plaintiff and or its predecessors and interest in the 512 mark since at least 2012. So they're basically establishing that they have been using this as a trademark so far, so that they should be provided trademark protection for this case. Defendants without plaintiff's authorization has begun selling tequila using infringing marks. Upon information and belief, defendants' use of the infringing marks started years after plaintiff's use of the 512 marks. I think that Kendall Jenner came out with this tequila in 2020 or 2021. So they're saying, hey, we started in 2012. They started in 2020 or 2021. This is substantially after when we started. So they should be held liable for trademark infringement. Okay. And the infringing marks as used by defendants are deceptively and confusingly similar to plaintiff's 512 mark. On information and belief, the goods and services with which the defendant uses the infringing marks are primarily of the same nature as the goods and services with plaintiff's use in the 512 marks. On information and belief, the goods and services with which defendants uses the infringing marks are marketed and sold in trade channels that overlap with those used by plaintiffs for goods and services. So they're saying they basically are selling a similar type of product and they sell it within similar channels. You will buy liquor at a liquor store. You will buy liquor online. Can you buy liquor online? Maybe. But you will basically see these two products at the same place. And so this is just what they're establishing here. And so let's pop back over there. All right. The goods and services with which the defendant uses the infringing marks are marketed and sold to classes of consumers that overlap. So basically, people that drink tequila. So they're going to be in the same aisle, at the same section, looking at the same bottles. If they are looking for tequila, you're going to be in the tequila section, right? And you're going to be into the liquor section if you're in a bigger store. So defendants' wrongful acts are, as alleged herein, have caused and are likely to cause confusion, mistake, and deception among the relevant consuming public as to the source of origin of the defendant's goods and services, and are likely to deceive the relevant consuming public into believing mistakenly that defendant's goods and services originate from or are associated or affiliated with or otherwise authorized by plaintiffs. These people are putting a lot of words in their sentences in this complaint. All right, regardless of the quality of defendant's product, such confusion puts plaintiff at the mercy of defendant. Such loss of control is irreparable harm in itself. Defendant's wrongful acts as alleged herein further in commercial advertising and promotion misrepresent the nature, characteristics, qualities, and origins of defendant's goods and services. And then further, they say defendant's wrongful Conduct as alleged herein has directly and proximately damaged plaintiff, including to its business relationships, goodwill, loss of sales opportunity, diversion of the market share, and lost revenue. And unless enjoined will continue to do so, plaintiff has no adequate remedy at law. So, with this case, they are basically saying that everything that Kendall Jenner's company is doing is going to cause them to lose money, or it has already caused them to lose money. And so they want to stop them from being able to market their tequila under this trade dress and under this name, because it can actually lead to them actually making more money and saving their actual brand. As they stated earlier, Kendall Jenner has already been under wraps about this tequila brand for the cultural misappropriation. In the times that we are in now, people are not dealing with appropriation, misappropriation, stealing from different cultures without giving them acknowledgement, without appreciating it. And sometimes they just don't want you using their culture in general. So being under wraps for cultural misappropriation or cultural appropriation at this day and age, especially, is not beneficial. And this tequila company recognizes it. So they want Kendall Jenner's company to stop, or KN Soda LLC, whatever it's called. They want them to stop. Okay, so let's pop back over to the actual complaint here so you guys can see. The first thing is for trademark infringement under the Lanham Act, which is just the trademark law, basically, the statute for trademarks. And they're saying that it's unauthorized use with the 81A is infringing herein and is a reproduction, counterfeit, copy, or colorable imitation of plaintiff's 512 word mark. Defendant's unauthorized use in commerce of the 818 within the infringing marks as alleged herein is likely to deceive consumers as to the origin, source, sponsorship, or affiliation of plaintiffs or of defendants' goods and services, and likely to cause consumers to believe, contrary to the fact, that defendants' goods and services are sold, authorized, endorsed, or sponsored by plaintiff, or that defendant is in some way affiliated with or sponsored by plaintiff. These lawyers use super long sentences. I don't know what's going on here, but I'm out of breath reading these sentences. Defendant's conduct, as alleged herein, constitutes trademark infringement of plaintiff's registered 512 word mark in violation of the Lanham Act. Defendant has committed the wrongful and unlawful acts described herein with full knowledge. So they're basically saying they're infringing on this conduct. They knew about the 512 bottles and they continue to go ahead and copy the bottles. So they are saying that this trademark infringement is willful and that they should be held liable for it. All right. And with willful intent to cause confusion in trade on plaintiff's goodwill. And basically, if they can prove intent, they basically win more money. So you want to be able to prove intent on this situation in order to get more money. They're basically saying it will cause immediate and irreparable harm and injury to plaintiff, including to its goodwill, reputation, and will continue to directly and proximately damage plaintiff and confuse the public unless enjoined by the court. Plaintiff has no adequate remedy at law. Plaintiff is entitled to, among other relief, injunctive relief and an award for actual damages, defendant's profits, enhanced damages, reasonable attorney's fees, and cost of the action. And they're saying this within a pre-judgment and post-judgment interest. And so what they are actually asking for in this situation is they want to be able to stop Kendall Jenner's company from using this trademark and selling under this trademark. They also want to be awarded actual money for the violation. They also want to be awarded any profits that Kendall Jenner's company has acquired through using this trademark. and they want also attorney's fees. So they had to pay attorneys in order to write this complaint for them and bring this action. And they're basically saying that if Kendall Jenner's company never copied us, I would have never had to file this lawsuit and I wouldn't need these attorney's fees. But since they would not stop copying us, we filed this lawsuit and they are basically responsible for paying my attorney's fees and asserting my rights. And then the cost of the action, of course, is included within that. Okay. Let's turn this off. Over the comments. Okay, no comments here. All right, the next thing that they're alleging is unfair competition and false designation of origin. And they're basically saying that the defendant's unauthorized use in commerce on the infringing marks is likely to deceive consumers as to the origin, source, sponsorship, or affiliation of the defendant's goods and services. It's likely to cause confusion to believe that Kendall Jenner's company is associated with this 512 company, or that they sold, authorized, endorsed, or sponsored them to do so. And that they're basically saying if they're affiliated or sponsored by the plaintiff, so sponsored by 512. Defendant's conduct constitutes false designation of origin and unfair competition, and it violates the trademark laws. Upon information and belief, defendant has committed wrongful, unlawful acts described herein with full knowledge of plaintiff's prior rights in the mark. So they are emphasizing that Kendall Jenner's company actually knew about this 512 trademark, and they're alleging that they actually knew because they actually reached out to them and told them that they were copying their product design in the Kim Kardashian app. So they cannot deny that unless they only sent that notice to Kim Kardashian's company, because that wouldn't include putting Kendall Jenner on notice as far as providing like written notice that you actually notified them. They would have had to notify Kendall Jenner's company and Kim Kardashian's company. So they can't just send it to Kim Kardashian and say, oh, well, that's your sister, so you should have told her. It doesn't work like that. Yeah. So basically alleging that it's causing harm to the goodwill, and they're asking for the same type of damages. So they want them to stop, they want money, and they want them to pay the attorney's fees and any profits that Kendall Jenner has gotten since representing or using the brand 818. Okay. All right. So the next count that they're alleging is trademark infringement under the common law, and which again is going to be the same as the federal, but they're just doing it under common law protection as well, because they only have one federal registration. And normally when you are doing some type of lawsuit for trademark infringement or anything of that nature, if there is a federal law and then there's common law, then you want to sue under both of them just to give yourself the most protection and to be able to put in the most facts that show that these people are violating your rights. So they're basically alleging like that they have continuous and exclusive use. They have acquired distinctiveness so that their trademark is unique and people should not be able to use it to market their goods, i.e. Kendall Jenner should not be able to use their trade dress and a similar name that they have in order to market their 818 tequila brand. Okay, and so they just go on to say that the use of this trademark was unauthorized and that they are basically causing harm to the 5112 trademark because Kendall Jenner is a big celebrity and is likely diluting the exclusivity of their mark. Again, they are alleging unfair business practices under the common law. And so in this one, it's a little bit different than the trademark infringement. So we'll go ahead and read what the attorney decided to write here. Through his actions and alleged herein, defendant has misappropriated plaintiff's efforts and are trading on or otherwise exploiting the 512 marks and plaintiff's reputation to the market. defendants own goods and services under the deceptive and confusingly similar infringing marks. These actions are unlawful and fraudulent business acts or practices that have harmed and continue to harm plaintiff, constituting unfair competition in violation of California Business and Professions Code. So, again, they are saying that they would like for them to stop and for them to be paid for them harming their actual rights under this law. And then next, we have a common law unfair competition, which is going to be the same as the federal unfair competition. They misappropriated plaintiff's efforts and are trading on the otherwise exploiting the 512 marks. They want them to stop and they want money from it. And then so we go on into the prayer for the relief. The prayer for relief is basically where the plaintiffs ask for what they want to happen in the case. So they're asking for a preliminary and ultimately permanently enjoining the defendants and anyone else associated with the 818 brand from using the infringing marks, otherwise infringing on the 512 marks, requiring that all documents and things in possession, custody, and control of such enjoining persons or entity, including the products, the packaging, internet websites, advertising, promotional material, sales, and marketing plans are delivered to the plaintiffs. So they want them to give them everything that they use for that business, for the 818 business. They want them to give it to 5112 to ensure that they don't continue to infringe on their rights. And they also want them to deliver a report to them within 30 days under oath stating that they have complied with this injunction that 512 is seeking. And then they also want a judgment entered on counts 1 through 5, granting monetary relief and which includes actual damages, defendants' profits in conjunction with accounting of defendants' profits, and wrongful and unlawful sales and enhanced damages. They basically just want money. They want them to pay them for all the harm that they caused them. This includes any profits that Kendall Jenner may have made from selling products, because in their eyes, the people that bought the product could have easily been confused and thought that they were associated with the 5112 brand. So basically, they're asking for money in regards to the actual trademark infringement. Next, they are asking for attorney's fees. So they want Kendall Jenner to actually pay for their attorney filing this complaint. And then they also, of course, ask for any just remedy that the court deems acceptable under the law. So they're basically just doing a catch-all, throwing the spaghetti at the wall to say, oh, if we missed any remedies, they are still allowed, because we basically reserved it by saying other and further relief as the court deems just. So any other relief that the court thinks that they are entitled to, that they should get it. All right, so that case took a little bit of time. Let me know what you guys think of it. If you are watching on the replay, go ahead and comment below. Let me know if you think that these are pretty similar. I'm gonna go back up to the picture real quick just to show people that may come in the middle or a little late, to kind of show you what the infringing or the claimed infringing bottles look like. So I am going to pop back over here for you guys to see. What do you think? Do you think that this is confusingly similar? Oh, I didn't know I could do that. Yep. So this is the bottle. This is what they're saying is trademark infringement. Trying to make it bigger for you guys here. All right. So this is the bottle. Do you think it's similar, or do you think that maybe people would be able to tell that it's different if you were in a store and you saw these bottles next to each other? You would be able to tell that they're different. You wouldn't think that these are the same brand. I think they're just so close in color. But I also feel like I've seen other alcohol bottles that are very similar, and you just kind of have to read it and make sure you're buying the right thing. But a lot of times it's also because the bottle that looks similar is actually the generic brand and they have permission to copy it. So let me know if you guys think this is similar. If you're watching this on the replay, let me know if you think it's similar. I know I asked a couple of times, but I just like to see what your opinions are on what is going on in the case. So we will go ahead. Oh, you can see my flowers. I didn't know that. Okay. Let's go on to the next case. We're going to be talking about the Ace family. If you guys popped into here a little late or you're watching on the replay and you skipped a little bit of the situation, let me re-explain who the Ace family is. They are a social media influencer family, hence the name the Ace family. They basically do pranks on YouTube, do videos on YouTube, and they involve their children. A lot of people have problems with them simply because people think that they are using their children for profit, i.e., the kids are like the star of the show, according to a lot of people. And then the parents go and buy these lavish things, these big houses. They basically sell things to children because most of their fan base are children, and they promote their products to them. They promote anything that they're selling. And this family or these parents have engaged in so many business deals that have turned out to be sketchy. People are not a fan of them. So they are the Ace family. Let me go ahead and pull up a picture of them so you can see who they are, just in case the name is not ringing a bell. And I won't show the children because of YouTube guidelines. So let me see if I can find them. Here is a picture. Oops, that was actually a video. So let me pop up who they are. It's giving me too many pictures with the children. So let me see. Bear with me for a second here. Let's see. All of these are, because I clicked on the video tab. That's why they're all videos. Smart one. Okay, here we go. Here is the McBroom family here. Let's see. This is the McBroom family, Austin and Catherine McBroom. These are the parents to the Ace family. And these are the people that have about over 10 lawsuits going on. They were in charge, Austin was in charge of the social gloves fight that didn't make enough money. So a bunch of companies sued him for that reason. They actually just recently settled a lawsuit involving the social gloves. And then this lawsuit got filed. So they got out of one lawsuit just to get into another lawsuit. So we're going to go ahead and go through it and kind of talk about what they have going on. Like I said, I wasn't going to cover this case before, but it did pop up, and I actually covered one of their cases in the past, and it was a big hit. So I know a lot of people on YouTube are interested in the lawsuits that they have going on just because they've been probably scamming for so long. People want to know like what they're being sued for. So again, we're going to go through the complaint, and remember, everything in the complaint are alleged facts. It does not necessarily mean that it is true. It has not been proven to be true as fact. It is just what the plaintiffs are actually alleging in their complaint. Catherine McBroom, Austin McBroom, and their company that is being sued will have the opportunity to answer in the court of law and give their own facts. So hopefully they will. Like I said, this case was just filed. Let me go down and see when it was filed. But this complaint is super long. And so when I do these complaints, you actually have to pay for them. So this one was quite expensive just because the California, the way the California, LA, Los Angeles County Court charges is ridiculous. So this was like the most expensive complaint that I have ever bought for this channel. So let me just pop it back up so that you guys can see what's going on. And boom. So Catherine McBroom's company is being sued. And so I actually covered, let me just do it. Yeah, I actually covered the case involving this cosmetic line a little earlier on my channel. So if you are interested in the Ace family, or if you are just interested in lawsuits in general, make sure you go and check that one out. The mother in this case, which is Catherine McBroom, the mother of the Ace family, I would say, she has a cosmetic line, which is what she is being sued about here. And I covered the actual case where the company that put the products in packaging sued the actual cosmetics company, or Catherine McBroom's company. So if you're interested in this case, make sure you go out and check, or make sure you go and check out my pre-recorded video where I kind of did editing and everything of the video about the lawsuit between them breaching their contract and the fact that they owed like $700,000 based on not paying the packaging company. I think they might have also settled that case too, if I'm not mistaken, but I'll have to double check on that. So don't take that as law. So I will pop back over to the McBrooms here. Can I make? Oh yeah, that's how we make it beautiful. All right. So as we can see, TBL Cosmetics is suing Catherine McBroom, Austin McBroom, which is the husband, and 1212 Gateway, which is the company that is ran by Catherine McBroom and Austin McBroom. And you'll see why they're named here in a second. And as you can see, this is a big lawsuit. There are 8 causes of action. They're suing for breach of contract of a settlement agreement, an operating agreement, fiduciary duties, covenant of good faith and fair dealing. They want declaratory relief. They want removal of these people as managers on their company. They want the court to initiate appointment of a new manager or provisional manager, and they are suing for fraud by inducement. So yeah, these people are in some hot water. As I take a sip of water. All right, so let's get into the shade that is the complaint. Plaintiff TBL Cosmetics, both in the individual and representative capacity, insofar as this is derivative account brought on behalf of 1212 Gateway. Now remember, 1212 Gateway is listed as a defendant in this case, but they are also derivatively listed as a plaintiff in this case, and we're going to get into why that is in just a moment. The case is basically brought by TBL and derivative on behalf of 1212 Gateway, and it is against Catherine McBroom and Austin McBroom as follows. And this is where the nature of the action comes in. They're going to give us a little brief description, or not even a brief description. This is a long description of what brought this case to be, okay? This action concerns social media influencer and internet celebrity Catherine McBroom's breach of the terms of the August 19, 2021 settlement with TBL Cosmetics. In addition, Ms. McBroom has violated 1212 Gateway's operating agreement and failed to fulfill her fiduciary duties to the company and its members, all while 1212 Gateway is losing revenue, its customer base, and has claims against it by vendors and creditors. Remember, I said 1212 Gateway was actually sued by the packaging company of these cosmetics because they never paid them for the packaging that the products were in, which is ridiculous because we're going to get into the amount of money that this 1212 Gateway company made on its launches. So they should have more than been able to pay back for at least the packaging, but apparently they have vendors and creditors. Vendor creditors, and it's an S. So to me, that sounds like they have multiple people that they owe. Miss McBroom's actions have severely damaged 1212 Gateway, and her ongoing refusal to fulfill her obligations to the company requires her removal as a manager and other possible equitable relief. other equitable relief. So they want her to be gone as the manager on 1212 Gateway. TBL is a well-established cosmetic company formed by seasoned professionals with specialized or that specialize in creating, building, and scaling cosmetic brands. Miss McBroom, a member of the YouTube Ace family, along with her husband Austin McBroom, sought to capitalize on her internet fame by collaborating with TBL to develop, market, and sell a line of skincare products. Miss McBroom was the face of 1212 Gateway, while TBL was the brains, lending its considerable expertise to building the company, running its day-to-day operations, and strategically positioning 1212 Gateway for long-term growth and success, including beyond Miss McBroom's influencer circle. 1212 Gateway had initial success due in large part to TBL's role in planning, positioning, and running day-to-day operations of the company, and when Miss McBroom performed her marketing obligations, the company benefited. But major issues soon arose between Miss McBroom and the management of TBL because of her failure to perform her obligations. So they're basically saying that the company was successful until Catherine McBroom stopped doing what she was supposed to do. The McBrooms attempted to improperly take control of the company and oust the CEO and officer and TBL executive, in effect an improper corporate coup. So they basically kicked TBL out of the operation so that 1212 can run the company on their own. In April 2021, TBL was forced to file a lawsuit against Ms. McBroom, both individually and derivatively, seeking damages in excess of $30 million. On June 28, 2021, the clerk court entered TBL's request for a default, and on August 12, 2021, TBL requested judgment by default in the action. And so before we jump into the rest of the complaint, I do want to explain to you guys what a default judgment is. What happens when a default is entered is that you basically lose the case. So this company, TBL, filed a lawsuit against Catherine McBroom, and Catherine McBroom never answered the complaint. So TBL was able to get a default judgment against her, and they would have been able to collect on that default judgment. What happens when you get a default judgment entered against you, or you get any type of judgment entered against you in California, it goes on your credit report. So since she had a default judgment entered against her, the court could allow TBL to say the amount that is owed, show them accounting of what was owed to them, and enter that amount against them. So if they were able to prove that $30 million was really owed to them, they could have had a default judgment for $30 million. That would have bankrupted, I'm assuming that it would have bankrupted Catherine McBroom and any of her companies, because they have so many lawsuits going on. And if they really had the money to pay people back, then they probably would have paid it back. And their house also got foreclosed on. So in my humble opinion, I do not think that Catherine McBroom has $30 million available to pay any judgment. So they got a default judgment against her. But as we go through this case, you will see that Catherine McBroom actually showed up to the case and decided to enter into a settlement agreement with TBL, which kind of erased the default judgment, because they retracted it and went ahead and settled with a settlement agreement and dismissed the lawsuit that they had against her. And in my opinion, after reading this case, they probably should have just kept the default and tried to collect on their judgment. Again, they probably wouldn't have been paid, because I don't think she has the money, but at least they would have been stopping her from starting more businesses, because she would have had at least two bankruptcies under her wing. But they decided to be nice and to try to see if they can work out a settlement agreement, and for Catherine to actually participate and kind of work her way back into being into trust with TBL and finishing their business venture that they had. Okay, so back to the complaint here. Oh, wait. Yes. All right, back to the complaint here. Spurred by TBL's success in court, Ms. McBroom begrudgingly, like I just said, begrudgingly engaged in negotiations with TBL based on McBroom's promises and representations. The parties entered into a confidential settlement agreement, which we do not have because it's confidential, and mutual release on August 19th, 2021. Based on the agreement, Ms. McBroom promises and Ms. McBroom's promises, TBL agreed to dismiss the action filed on April. Again, getting rid of that default judgment against her. So it's not on her credit. And I'm thinking that it's not on her credit because they would have had to remove the default judgment in order for them to go forward with this settlement agreement. All right, and so they had this operating agreement, which also amended the settlement agreement also amended the operating agreement, and they have attached the operating agreement to this lawsuit. However, Ms. McBroom was willingly and knowingly, or has willingly and knowingly refused to perform in accordance with the terms of the settlement agreement. An article of the settlement agreement requires Ms. McBroom to make certain social media postings and promotions on various accounts on a specified schedule. She has not met any of her obligations. Furthermore, the settlement obligated the parties to nominate candidates for a vacant manager position on the board pursuant to the operating agreement. Ms. McBroom has refused to participate in selecting that individual. This has essentially left the board deadlocked with two managers from TBL and two under Ms. McBroom's control. Ms. McBroom's actions harm TBL directly, have depressed the value of the company, and have prevented it from reaching its fullest potential. Furthermore, Ms. Broom's acts have negatively interfered with the 1212 Gateway's relationship with important vendors, i.e., they were sued by their packaging company because they haven't paid them, further damaging the company's reputation and business operations. Ms. McBroom has preyed upon the mercy, patience, and sincere desire to let bygones be bygones expressed by her partners. Such mercy and good intentions can only be stretched so far. So they are saying, despite the settlement agreement that they entered into, Catherine McBroom basically was like, man, forget all of that. I'm going to keep doing me, and you guys are going to take that default judgment back, and I'm still not going to help you make the business successful. This is what TBL is alleging in their lawsuit. So let me hop back over here. All right. Accordingly, TBL seeks by this lawsuit damages both already inflicted and to be incurred for breach of the settlement agreement and the operating agreement by Catherine McBroom. TBL and 1212 Gateway seek damages caused by I don't know why they put Miss and Austin McBroom, but basically Catherine and Austin McBroom's violation of their fiduciary duties. 1212 Gateway seeks all damages caused by defendant due to their breaches. TBL seeks declaratory judgment or declaratory relief that Ms. McBroom has materially and willfully violated the operating agreement, and TBL seeks both Ms. McBroom and Austin McBroom be removed as managers from 1212 Gateway for the breaches of the operating agreement. And they also want the court to appoint a provisional director for the company so that they can basically vote Austin McBroom and Catherine McBroom out of the company, and so that they can get moving on with the operations of the company so that it can continue to be profitable. However, I don't know how profitable the company would be because a lot of people did go ahead and complain about the products when they got it. They said it was a copy of another product. They said the packaging was bad. They said the product was bad. So I'm not too sure how profitable this company really would have been, despite everything that Catherine McBroom is doing, because a lot of people have already really complained about the product. You can find several reviews on the product on YouTube, on Google, wherever you want to look it up, okay? So they're saying that because Catherine McBroom did this stuff, this is why they're not making money. But it could be potentially because the products are not too good, allegedly. I don't know because I haven't tried the products, but I have heard a lot of complaints about it. So I'm not sure if this in particular is why they are losing money. Of course, the complaint goes on to list the parties in the case, which is Toto Gateway and Catherine McBroom and all of those people. They also established jurisdiction of the venue. Let me know if you guys are interested in me actually going over that part. I just try to save some of the time by skipping over that part because it's pretty like generic, and we're not going to be analyzing whether anyone's going to object to the venue because it is in the California County Court and or the Los Angeles County Court, and that is where she lives. So I don't see why she would try to object to the venue and jurisdiction because she lives there and she has been sued there multiple times, and their operating agreement says that is where she will be sued if a lawsuit were to come up. So it'll be very hard to get out of jurisdiction and venue in this case. So hopping back over to the complaint, let me know if you guys have any questions. Let me know if you already heard about this case. If you're watching this on the replay, let me know if you heard about this case. And let's pop back into the factual background. And like I said, this case is really long, so I'm going to try to get through it a little fast. A lot of the stuff does kind of repeat, so I'll try to catch that as much as possible. So let's jump into it. TBL is a group of seasoned professionals with extensive experience building business and developing environmentally conscious beauty and skin care products. Catherine McBroom is a social media influencer with a wide audience across YouTube, Instagram, and other social media outlets. While the two initially expected a good match of skills to create a profitable company, Miss McBroom has been a constant impediment to success. Basically saying that Catherine McBroom has not been assisting in propelling this company forward. They basically joined forces on August 7, 2020. The operating agreement includes a choice of law provision that's basically saying that whenever they get sued, it will be under the state laws of Delaware. Ms. McBroom was to be the public face of the company and responsible for marketing the brand to her followers through a combination of press interviews, promotional videos, and social media posts. All right. And they specifically call for no less than 100 posts in aggregate across Ms. McBroom's various social media feeds per year. These acts were Ms. Broom's material obligations to act on behalf of the company as the manager and as defined by the operating agreement. So she was supposed to make these social media posts. That was her job under this settlement agreement and the operating agreement, and she did not do it. Both Catherine and TBL are members of 1212 Gateway. And so when we're talking about members of the company, so remember 1212 Gateway is an LLC and TBL is an LLC. When you start an LLC, the owners of the company are called members. So they're basically saying that TBL, and as an entity, they can be a member of another LLC. So TBL is a member, Catherine McBroom is a member. And here on the lawsuit, it lets us know that Catherine McBroom has invested $280,000 for a 63% membership interest in 1212 Gateway. And then TBL invested sweat equity and $120,000 for a 30% membership interest in 1212 Gateway. And they say that an inactive California attorney has 7% interest from the McBrooms. And he's a non-voting silent member to the company. As they are members of the company, they are each entitled to designate 2 managers to the board with a 5th independent manager to be mutually agreed upon. So they need to vote on the 5th one. So each of them have 2 managers One of the managers is Catherine McBroom. The other manager is Austin McBroom. And then they were supposed to agree on the third manager. And then TBL has 2 other managers of their own. So in total, there would be 5 managers. And then they also let us know that Catherine McBroom just kind of stopped attending the board meetings and was sending Paul Caesar, which is the inactive attorney, to represent her by proxy, in quotation marks. And by proxy in a corporation basically means, and I said corporation even though this is an LLC, because you can usually include proxy voters in corporations, not necessarily LLCs. I guess you can write that into your operating agreement, but it is more common for a corporate entity to have someone there to vote by proxy. And it's basically just someone sitting and filling in your seat and handling your part of the duties within your corporate meeting. So TBL is saying that Catherine McBroom was sending someone in to vote on her behalf and handle the LLC meetings on her behalf by proxy, but that wasn't in the operating agreement. And like I said, it's more common in a corporate setting than in an LLC setting. So that is why they're bringing that up. And then they're saying under the operating agreement, any manager can be removed by failing to or by breaching the operating agreement. Okay, or failing to provide their duties under the operating agreement as well. Okay, I've been talking for an hour and 20 minutes. So, my voice is getting beat up here. All right, so TBL goes on to let us know what they did for the company and basically that they participated in their part in building the company. Remember, they said that they put sweat equity into it. And so this is just a list of the things that they did in order to fulfill their part of the LLC partnership or membership of the LLC, right? So as it has previously done with other business endeavors, TBL developed and oversaw the foundational aspects of 1212 Gateway. The chief scientist devoted her efforts to the scientific formulation of premium quality, naturally derived skincare using carefully derived precision methodology to ensure a consistent and satisfying experience for the consumer. Again, there are a lot of reviews saying that they use the exact same formula as some other companies that are out there that was actually created by TBL as well. So questionable whether she devoted so much time in developing this particularly for 1212 Gateway, but nonetheless, this is what they are alleging. But I'm just saying what is out there in other videos that they're saying the formula is the same as a lot of other companies, allegedly. TBL drew upon its industry expertise to best position 1212 Gateway for success throughout a combination of strategic financial planning and long and short-term cash flow and management. They leveraged key vendor relationships to negotiate product supply advancement, advantageous production schedules, and payment via installment. Again, they probably didn't do that well because 1212 Gateway did not pay the packaging company. But nonetheless, we move forward. All designed to ensure a continuing ability to grow the company. They also built out a robust fulfillment and shipment infrastructure, allegedly, establishing connectivity across online platforms, including the website, which derives company commerce, Shopify, and Shipping Tree, their fulfillment program. Alrighty, so drawing upon its prior experience, TBL also ensured 1212 Gateway had a dedicated customer service team to promptly and effectively handle all customer inquiries to ensure the utmost customer satisfaction. Remember this, they said they had a customer service team in place. But again, there were some allegations against that customer service as well on the internet streets, but we're not talking about that, so we'll try to stick to the complaint. But remember that they said they had a customer service team in place because later on in the complaint, they're going to let us know that they agreed to have one of Catherine's companies take over customer service in that settlement agreement. TDO ran 1212 Gateway day after day, building up the company's initial launch and restock events, ultimately creating proprietary turnkey systems that work exceptionally well. Basically saying that they established the company to run as smoothly as they did. All right, so they were formed in 2020. It has performed far beyond the expectations and is already a global brand. The level of success enjoyed by 1212 Gateway to date is a direct result of TDL's leadership in day-to-day management. Basically saying that Catherine McBroom did not do anything to make the company as successful as it has been. And we are about to get into the amount of money that they made with this product. So let's jump into it after I sip my water. Okay. At 1212 Gateway's initial launch on December 12, 2020, the company completely sold out of its inventory, selling over 1 million in products within the first 30 minutes. 2 weeks later, 1212 Gateway hosted a restock event, which also sold out. 1212 Gateway exceeded both its initially predicted revenue and the product development metrics. From the drop in the restock, the event created buzz and drove customer demand and expectation for more products. Had 1212 Gateway continued its upward trend, it stood to make $60 million in revenue by the end of 2021 and more by 2022. However, Ms. Broom has acted to the detriment of the company. So remember, they made $1 million on the first launch. Do they ever tell us how much they made altogether? I don't remember. But let's say they made $1 million on the first launch. The company, 360 Sourcing, I want to say it's called, sued them. They were the packaging company that Catherine McBroom and 1212 Gateway never paid. And so they sued them for $720,000 estimately. And yes, they did settle that case. I remember. I think I have the complaint on that one too. They went ahead and settled that case, and they ended up owing like $760,000, somewhere around that range, because of all the interest that accrued because of the lawsuit. So TBO is saying that they made $1 million in the first 30 minutes of the first launch, but somehow they were not able to pay the packaging company $700,000, which of course has accrued interest, turning it into $760,000 to $70,000. So, and they also had a second launch, so they should have been able to pay their packaging company. That's my whole point of that. They should have paid their packaging company because they made $1 million. But this might be why TBL is actually suing, because they're saying that their vendor creditors are an issue because Catherine McBroom is basically not running the company properly, and that they need them out of the manager seat so that they can operate this company properly and so that it can be profitable. So accordingly, I think TBL is claiming that they would have paid 360 Sourcing had they been able to get the decisions made despite or without Catherine McBroom and Austin McBroom blocking them. All right, so let's hop back over. Righty. So $60 million by the end of 2021. They were expecting to make $58 million in 2021. All right. Critically, the initial success was the tip of the iceberg. Thanks to TBL's vision and expertise, 1212 Gateway was positioned to reach consumers far beyond Catherine McBroom's social media followers. But never mind. Because if they could reach more people, then why are they so pressed about her posting? But anyways, let's go with what they're saying. 1212 Gateway through TBL has worked to expand its product line, yet despite the success of Miss McBroom, has failed to fulfill her obligations and duties and stood as an impediment to the growth and success. But again, they said they could reach more people than Catherine McBroom, so why are they waiting on her to comply? Unless it's just not as profitable without her compliance. Miss McBroom's attempted corporate coup, TBL filed a lawsuit and secured a default. So this part of the lawsuit is about to go over what happened with the previous lawsuit from April 2021, which they ended up getting the default, which they ended up dropping because Catherine McBroom said that she was going to participate in the operation of this company. So let's get right into it. And this is also long, so we are going to zoom through this. Due to the initial success despite her own failures, Catherine McBroom inexplicably attempted a corporate coup through various schemes to wrest day-to-day control of TBL. In March 2021, she improperly obtained various administrative access credentials, changed passwords, and kept TBL from the proper role in the company. They engaged in good faith negotiation, but she continued not to give them the passwords back. During the time, Ms. McBroom mismanaged the operations and infrastructure, costing immeasurable goodwill and reputation. Basically saying what she did ended up ruining the reputation of the company. She continued to exclude TBL from the vital corporate systems and seized control over 1212 Gateway's customer service operations, turning it over to family members. So she basically took everything that TBL was doing and gave it to her family members to do, including making the products and holding the products. Throughout the time TBL was locked out, 1212 Gateway missed opportunities. Chaos ensued because of Ms. McBroom's mishandling of operations, leading to increased volumes of negative customer feedbacks, complaints about shipping issues, and other unaddressed inquiries. So this section is basically going over the fact that Catherine McBroom basically tried to do a corporate takeover and push TBL out. And when she did that, she basically messed up the company. Shipping was complained about, customers would complain about the products, the packaging, all kinds of stuff. Kind of what I was talking about earlier. Importantly, this corporate hijacking stunted product development and scaling of the company as a whole. This also resulted in the impairment of 1212 Gateway's ability to gain additional supply advancement from vendors, unnecessarily and significantly limiting the company's ability to quickly scale to its full potential. This has hindered 1212 Gateway's ability to negotiate more favorable terms for product development and shipping. Remember, the packaging company sued them because they did not pay. And TBL is alleging that this part of the process was under Catherine's control. So if she would have been actually paying, then they wouldn't have had this issue, is basically what they're saying. So, all right. If that was not enough to harm the company, Ms. McBroom informed TBL that she intended to unilaterally and without a vote by members dissolve the 1212 Gateway LLC. She attempted to use this threat as leverage to require TBL to accede to her demands to control operations, oust the CEO, and endeavors to appoint a new CEO and brand manager. This ignored the operating agreement and it greatly harmed the company, resulting in delays in marketing and increased the overhead costs, the inability to negotiate beneficial terms with vendors, and significant loss in profit. So basically, everything she did kind of messed up the company. All right. So with Ms. McBroom acting in such flagrant disregard of the operating agreement and her manager duties, TBL had no recourse but to file the civil claim. And that is when they brought the April 12, 2021 lawsuit against them for promissory estoppel, breach of fiduciary duties, and cyber squatting violations because she stole the passwords, remember? So cyber squatting. And so they basically sued her for damages and punitive damages. And with that lawsuit, Ms. McBroom or Catherine McBroom did not mount to defense, meaning she never responded to the actual complaint. And she was in default. So at that point, like I explained earlier, the court is able to award the plaintiff whatever money they request and that they can prove. And then the judgment would have been entered against her, and it would have been against her credit. And she likely would have had to file bankruptcy, which the internet would have had a ball with that, because a lot of people talk about a lot of the lawsuits that the Ace family has. They tried to claim that they were not getting foreclosed on when that's public record. Now, if this bankruptcy would have happened, that would have been another explosion in the Ace family world of facades, and they probably would have told us that they're not bankrupt either. But remember, Catherine McBroom and the 1212 Gateway LLC was actually named as defendants, so the judgment would have been against both of them. So she probably would have been bankrupt because, like I said earlier, in my opinion, I do not think that she has $30 million laying around to pay TBL for their efforts. Okay, let me get 1 second. All right, back to the complaint here. We are back to the complaint here. All right, so Ms. McBroom enticed TBL to enter into a settlement and mutual release with no intent of performing her obligation. So remember, she actually entered into this settlement agreement, and according to TBL, she has not performed any of the things that she was supposed to perform under the agreement. So let's check out what they have to say about her not abiding by the settlement agreement that she entered into. Within a few days of attaining the default judgment, Catherine McBroom, she fully engaged against Catherine McBroom. She started to engage in discussions with TBL, desire to get 1212 Gateway back on track and to continue to work with Catherine McBroom in her marketing role, deciding to negotiate an agreement. Ms. McBroom promised that she would give her best efforts to make 1212 Gateway a success. Based on these representations, TBL and 1212 Gateway agreed to dismiss the case. And again, I don't know what's going on over here on my phone here. Sorry, guys, I am over here struggling to keep my electronics working over here on my end. Okay, back to the lawsuit. They negotiated an agreement with her, and TBL agreed to dismiss the lawsuit against her. So remember, that default judgment, boom, disappeared. No credit hurting, no bankruptcy in the process, okay? So they went ahead and did that for her. On August 19th, they entered into the settlement agreement. 1212 Gateway was not a party, so they are not obligated to the terms of the settlement agreement or the mutual release. And basically, it said if she does not abide by the agreement, then they will be able to basically bring another lawsuit against her. All right, the settlement agreement confirmed TBL's responsibility for the day-to-day operations, meaning that Catherine McBroom needed to give back the passwords, and then that Catherine McBroom will continue to provide creative direction for product development and marketing. So she needs to post on her social media accounts to promote their products so that they can make some sales and so that they can build back up their goodwill. The settlement agreement also contained provisions that acted as amendments to the operating agreement. Sections of the settlement agreement required the parties, TBL and Catherine, to convene to act together in selecting the independent designee for the open board seat. So they needed to vote on someone to be the other board manager so that they can start making decisions in the company. Because right now they're deadlocked because 2 people belong to Catherine, 2 people belong to TBL. So whenever they voted on anything, it will be at a standstill, a deadlock, because they could not agree. Basically saying and then she was also supposed to make social media postings and come to monthly marketing meetings so that everybody will be on the same page. As a result of the settlement agreement, all technologies, passwords, everything had to be given back to TBL, which she did give them to them. On the other hand, the operating agreement amended. Remember, I said this earlier, that Ace Hat Collections, a company owned by Austin McBroom, would now be in charge of the customer service and fulfillment for the 1212 Gateway Company. Not a good idea. Like, did TBL not see all the lawsuits that were coming because of the Social Gloves event? Did that happen before or after this? I don't remember. But let me tell you, the Ace family has a lot of lawsuits against them. They recently lost their home. I would not hire any of their companies to do anything for me because they're always getting sued because they don't pay their bills. Allegedly. Allegedly, they don't pay their bills. And allegedly, they don't answer lawsuits. Not a smart idea, but whatever. TBL agreed to file a notice of dismissal, so they didn't dismiss the complaint in the default judgment. In the event of an action or proceeding to enforce the settlement agreement, the prevailing party shall be entitled to recover reasonable fees and costs. So, since Catherine McBroom did not oblige by their agreement under the settlement agreement, they're able to sue her and request that she actually pays their attorney's fees. So whatever they win in this lawsuit, plus whatever it costs to pay their attorneys, Catherine McBroom will likely be liable for it if she is found to win. All right, moving right along. She failed to perform her obligations under the settlement agreement. Again, another long section. This is a long complaint, guys. Okay. The parties executed the agreement on August 30th, 2021. Ms. McBroom immediately and materially failed to take her obligations under the settlement agreement and the operating agreement seriously. So she basically agreed to the settlement agreement and then didn't do anything. She was like, I'm gonna do that. Yeah, I'm gonna make sure our company is successful. Yeah. Okay, disappeared. Like, what? They should have just kept the default, which we'll see. We will see if she responds to this actual lawsuit to see if she doesn't get another default entered against her. And hopefully, if it is a situation where a default exists, that they won't listen to her and they'll keep the court order default and send her to bankruptcy, because that's messed up that she did that. Okay. Despite the unambiguous requirements for social media postings in both the operating agreement and settlement agreement, Catherine McBroom has failed to meet schedule and frequency of the social media postings. She refused to attend monthly marketing meetings and work collaboratively with TBL for the benefit of 1212 Gateway. Catherine has refused to agree upon an independent board member, which they were supposed to vote on. And Austin McBroom has failed to satisfy his duty as a manager of 1212 Gateway. He basically does nothing, is what TBL is saying. On information and belief, Ms. McBroom has continued to exclusively promote her own personal and family interests while refusing to market for the company. The Ace Family YouTube account indicates frequent recent posts pushing products for Ace Family merch on the online portal. In addition, on February 6, 2022, which was 2 weeks ago, YouTube posts featuring Catherine and Austin promoted MaryRuthOrganics.com and providing a discount code for wellness goods. So they're promoting a business that sells similar things to them. It's for face and body creams is what they were promoting. Clearly, they are actively promoting competitive products while failing to promote the 1212 Gateway products despite her legal obligations. They have been consumed with a host of legal issues since mid-2021. This is what I'm talking about. They have been sued. They have about 12 lawsuits going on, or 12 or more lawsuits going on right now. Everybody's suing them. They're foreclosed on their home. All of this stuff. They're not paying their bills, allegedly, to present. they started in mid-2021 to the present, created by their mismanagement. Again, why would they have trusted them if they're not paying anybody else? Why would they believe that they will pay them? Or I guess it's not a payment situation. This is due to them just not doing what they said they were going to do under the contract, which is what happened with all these other things that they're being sued on as well, i.e. their mismanagement that TBL is alleging. Catherine and Austin and the entity they control, Simply Greatness Productions, have been sued for $100 million by a former partner for defamation based on the harm to their reputation. LiveX Live, which is the person that sued them for $1 million, alleges, amongst other claims, that McBrooms failed to market and promote a celebrity boxing match, which is the Social Gloves event. So yeah, that lawsuit, I looked this company up last week, Simply Greatness Productions. They have 4 lawsuits against them just involving the Social Gloves. I think one has been dismissed. So they have a lot of lawsuits going on against them, and those are not the only ones that they have. Like I said, they just settled the one with the packaging company for this cosmetics brand. So they're getting sued left and right, guys. Okay. They're saying that the McBrooms failed to market and promote the match, resulting in dismal sales and viewership. Basically alleging that the way that they promoted that boxing match is similar to the way that they're promoting this cosmetics line, basically showing a repetitive nature of them not fulfilling their contractual obligations. All right, alarmed by Catherine's immediate failure to follow through with the terms of the settlement agreement, has attempted to manage the company in the best way possible. However, due to Catherine's failure to provide marketing and drive product demand through her social media postings, the company has suffered a lack of sales. At the same time, various obligations to creditors and vendors have accumulated in the at least one lawsuit and other time demands by TBL, taking away from core operations and management. Despite this, TBL has attempted to negotiate with Catherine to encourage her to fulfill obligations under both the settlement agreement and the operating agreement. TBL has submitted various written and verbal offers, which have either been ignored or countered with unreasonable propositions. Okay, the next part of this is demand futility. They're basically saying that they did not file this lawsuit on behalf of 1212 Gateway against Catherine McBroom and Austin McBroom because they still own half the ownership in the company. So anything that they vote on, they're not going to agree to it. So if TBL comes to Catherine and Austin and say, hey, we want 1212 Gateway, which is their company, to sue Catherine and Austin, they're going to be like, no, we don't agree that our company should sue us for anything. So they're basically at a standstill. So they call it demand futility, and basically they're not going to file all the way on behalf of 1212 Gateway because they would not be able to get the managers to agree with the lawsuit. And that they will be in charge of both the prosecution and the defense of the case. So let's pop back over to the first cause of action. We're talking about breach of contract of the settlement agreement. Remember, she agreed to do these social media posts. She didn't do them. So they are asking for the court to award them with money damages. And what else are they trying to get them to do? They want the profit. They want them to pay any debt that they've incurred. All right. And I don't know. Yeah, I know later on in the case, they're going to want them to be removed as managers on the case. Again, they're saying they're breaching the operating agreement and it's causing damages to the company. And I'm just kind of going over this part quickly because they just kind of repeat a lot of the facts that we just went over, which took a pretty long time. So we're not going to repeat all of those. Again, they're talking about breach of fiduciary duty. And this is basically how they are not really acting on behalf of the company. And this highlighted part, I will go over that Catherine continue and willfully refusal has continued to refuse and to fulfill her obligations as manager have resulted in harm to 1212 business operations, its reputation with customers and vendors, and has kept the company from growing and reaching its potential. And as you can see, as highlighted, they are saying that Austin McBroom has done nothing to fulfill his manager duties, and basically saying that they should be removed from being managers under the company. Of course, they allege a little bit more aggressive things like that they're oppressive, reckless, malicious, outrageous, and willful disregard for 1212 Gateway, and that they should be liable for punitive and exemplary damages. So they should basically have to pay more money to make example out of the bad behavior that they have done, which is probably why they listed the other cases that they have going on, because it shows that they are intentionally acting bad because they keep doing it. You can't keep making the same mistake in different businesses over and over. Give it to you that they were like businesses started in the same amount of time, that at some point they have to correct their mistakes. They also suing for breach of covenant of good faith and fair dealing. The TDL against Catherine. She failed to fulfill her obligations under either a contract or has refused to fulfill her marketing and promotional duties, which has kept the company from realizing revenue and profit, hindering the operation of the company by failing to act as a manager should, and damage the reputation of the company with customers and vendors. And she still has not voted for the 5th board member, which is also putting the company at a standstill. So by doing this, they're saying that her conduct is harmful to the company. 5th cause of action is declaratory relief. They're basically asking for the court to come back with a judgment saying that she materially breached the operating agreement for not performing her obligations and refusing to select a 5th board manager. They also want a declaration that Mr. Austin McBroom, has willfully and materially breached his operating agreement by not performing his obligations and generally violating his fiduciary duties as a manager, because again, they are claiming that he has done absolutely nothing for the company. His name is just basically on there and he's doing nothing. And then they also want a declaratory judgment that Miss McBroom or Catherine McBroom has materially breached the settlement agreement by failing to perform as promised under the agreement. So they just kind of want the judge to decide that without necessarily taking it to trial. They're saying it's clear that they violated this, so that the court should just kind of decide on it as is. But of course, like I said, Catherine McBroom and Austin McBroom will have a chance to respond to this lawsuit. And I really just couldn't imagine being in their position, because they have so many lawsuits going on. They have their kids to take care of. They just got kicked out of their house. Well, they said they're renting the house, so maybe not. But they just kind of have a lot going on. And I could only imagine how it would be to have all these lawsuits against you, because I work with so many clients and I have all these lawsuits against other people. And I couldn't imagine if all these lawyers were coming at me with demands and wanting money and all of these things, and I'm the main target versus suing different people. They're the main target for a lot of these cases. So do I feel bad for them? Not really. They made a lot of money on social media, so they shouldn't try to allegedly scam their fans. So moving right along. And there are a bunch of things about them trying to scam their fans, and the harmful part about that is that they have a young audience base. So, but we're not talking about the world of McBroom scams, so let's get back into the complaint here. Okay. The next thing that they want is to remove Catherine as a manager, and they also want to remove Austin as a manager. They also point out that there is no section in the operating agreement that allows her to vote by proxy. So in that, she's violating her role as a manager. She needs to be showing up to the meetings, is basically what they are alleging. And then they're saying that they need to be removed because they are violating their duties under the operating agreement. The next cause of action is for them actually to appoint a provisional member, and they're actually asking the court to go ahead and appoint this person for the McBrooms because they haven't done so yet. And they're saying it's equitable for the court to do that, for them to have an impartial person to help move the company along, because it's just at a standstill right now because Catherine and Austin refuse to do anything. And then the last cause of action they have is fraud in the inducement. And they're saying in August 2021, Catherine McBroom made a promise to TVL that she would perform her obligations and fulfill her duties under the operating agreement and settlement agreement. She made this misrepresentation with no intent to perform when she made it. She made these representations to TVL executives leading up to the execution of the settlement agreement. She had knowledge of the falsity of her promises or reckless disregard for the truth. She intended to induce reliance by TVL in order for them to withdraw the legal claims and to enter into a settlement agreement. She had a default judgment entered against her in Superior Court and intended for TVL to dismiss the claim in reliance on her false promises. Remember, if they would have kept that default judgment, she would probably be in bankruptcy court right now, in my opinion. Okay? So TVL relied on Ms. Broom's misrepresentations that she would perform and dismissed the claims against her and entered into the settlement agreement based on her false promise to perform. TVL justifiably had the best interest of 1212 Gateway in mind and sought what was to benefit the company. All right, Ms. McBroom misrepresentation was the cause of the injury to TVL, as they have wasted time, effort, cost because of her failure to perform. TVL was not benefited as they should have because Ms. McBroom's misrepresentations of promises to perform her duties. So they're basically talking about how she told them she was going to perform, and then after they entered into the settlement agreement, she was just like, nope, not doing anything. We're going to go back to normal, and you guys are not going to have my credit affected by this $30 million judgment against me, which was smart but fraudulent on her behalf. So it's very questionable conduct for sure. By reason of foregoing of the conduct, TVL was damaged in the amount to be determined at trial, which damages are the natural and proximate consequence of the misrepresentation. They're also claiming that her conduct was oppressive, reckless, malicious, outrageous, and willful disregard to TVL's rights, so that they should be entitled to punitive and exemplary damages to the extent available. Now, to get into the actual prayer of relief that they're asking for, because of course they're asking for money, but at the end of the complaint, they do go ahead and break it down strictly and concisely for the court to see exactly what they're asking for. And so they are asking that the third cause of action be able to proceed on behalf of 1212 Gateway, basically for the court not to stop money to go to 1212 Gateway because of what Catherine and Austin are doing by not allowing or making any moves on the case. Declaring that Catherine McBroom has breached her fiduciary duty as a result herein and committed material breach of the operating agreement and settlement agreement. Same thing for Austin McBroom. Declaring that the board of 1212 Gateway is deadlocked in appointing a provisional manager. That way that there will be somebody else in there that is neutral, that will be able to vote on the matters that TVL is trying to get resolved. Removal of Catherine McBroom and Austin McBroom as managers of 1212 Gateway, and declaring they not serve as managers again. And I don't know if they're asking for them not to be able to be managers in any LLC, or if it's just for 1212 Gateway. They can never be managers again. For an award of compensatory and special statutory and exemplary damages in the amount to be determined by trial or determined at trial, an award for attorney fees and costs to the extent allowed by law, and for such other relief that the court deems necessary and proper. And so remember, when you ask for that, you're just kind of doing a catch-all, just in case you forgot anything that you would want the court to award to you. And this was filed on Valentine's Day, so a week and a day ago. So Catherine McBroom has a little while to respond. As you can see, this is a super long complaint because the exhibits are long. This is the operating agreement between the parties. If you were on the live stream last week, we talked about what an operating agreement is, and I actually have a clip coming out tomorrow about what an operating agreement is. So make sure you check that out if you are interested in learning more about operating agreements. We are not going to go through this one because it is a very long, very, very long. So we're going to skip all the way down. I think these are all still the, this operating agreement is ridiculously long. It's almost like bylaws. Yep. And so I'll also spell out the rules that they are alleging why they should be held personally liable because they were acting out of their scope as members and managers under the LLC. So let's pop all the way down. This is ridiculously long. What is that, 40 pages? These are not bylaws. Okay. And so we're going to go down to the schedule of who owns what. We see that Catherine owns 63%. We have TBL as earning 30%, and Mr. Paul Kaiser owning 7%. And they put $400,000 in to start this company. Here we have the board managers, which is supposed to be independent, TBL, McBroom. I feel like they just put this together for this lawsuit because they didn't even list who the managers are over here. They have this document to join 1212 as a party in this lawsuit. And then the product development agreement is to be attached. It's not attached yet, or not, it is attached yet. This is what they have here and what they're supposed to pay and everything that goes into the product development. If this is an agreement, this is very short and it's not signed. So I think that they put this together for the purpose of this lawsuit. And that's my opinion. I don't know if this is really what they are trying to say was the agreement. Or if, this might be a part of the actual bylaws. Not the bylaws, the operating agreement. Consent to member spouse, which is not signed. They should have probably put some signed things in there. These are the products that they initially started out with. Face creams, eye creams, cleansers, face masks, lip balm, sample pack, including all 5 products. All right, and then again, we're going to the contribution amounts. And that is the end of the complaint. So that was a very long complaint. Let's pop back over to full screen. And why is my camera out of focus? Okay, we're back in focus. All right. So that was the end of that lawsuit. If you guys made it all the way to the end of this live stream, it was very long and very fact intensive. So thank you for sticking it out with me on this lawsuit. And for the Kendall Jenner lawsuit, let me know what you thought about both lawsuits in the comment section down below because we are about to sign off. Remember, all the information that I give on here is to be considered legal information and not legal advice. If you have your own issues going on with your own business or your own life, make sure you consult with an attorney to help you out with your legal issues. I will see you guys in the next live stream or the next video or here on my YouTube channel and Instagram channel. So I will see you guys later. Thank you for watching.